Let's understand first about the Indian courts. Then we will go what is known as pleadings. Okay. Indian courts. See, earlier when there were Raja Maharajas in India, okay, king ruling was there. There was no democracy. King was known to be the head of the particular country or the particular state. That's why there were fights between the Mughals and our kings. Okay, so then at that point of time, the king used to be the judge, and whatever he said, uh, I mean, it was decided as per the king. There were no system of written evidences. Okay, so whatever king used to think fit, he used to pass the sentences. This is how we had a system of justice when we had kings. Then the Mughals came. Mughals also followed the same pattern about the kings. Mughals became the kings. They also ruled our country by having head office at Delhi. You know that, correct? And then later on, Britishers came in India. Britishers, see, some things we have received, which is very good. It's a blessing for us. Like we got English language, we got the systematic approach in the country. Like they gave us a system of courts. Earlier there was no system of courts, but we have borrowed that from the Britishers and we have continued that. And it's a good system. Then we had the system called as democracy. So nobody is king now. It is for the people, by the people, and we the people. This is what we have understood in the constitution. So now constitution is overall. Constitution gives power to everyone, and even constitution gives power to the Indian system of law. Very clear with this? Understood? You understood how our Indian legal system has been defined and where they get the power from. Okay. So, in the British period, there were certain courts like Diwani courts, high courts, etc. And then there was a smooth system, judicial system, and now our Indian judiciary is independent. I hope you all understand what is independency of a judiciary. Okay, this is how our Indian legal system was emerged. Now let's go to the introduction of the pleadings. Pleadings. In this particular chapter, we are going to talk more about Civil Procedure Code 1908, which you guys have learnt at your inter level, and few part of Criminal Procedure Code as well. Okay. So let's understand what is a pleading. See, whenever there is any fight between two people, like there is a debtor and a creditor. Debtor took a loan from the creditor with promise to repay it within 5 years. Within 5 years, debtor could not pay because of some reason. Creditor sued him. How did he sue him? He has to file a written complaint with the police or in the court of law. Okay. So then he filed a complaint in the court of law that is called as a plaint, and it's a civil suit. Okay. That's why it's called as a plaint. Whatever he has written is called as a pleadings. Then court will take that plaint into consideration. It will verify the matter, and if really court thinks is there is some case, then it will send this plaint to the defendant, that is the other party, that is a debtor, asking for the written statement, which is called as a defense. Okay. Then the other party will send its statement, that is a written statement answering the call of the court. All these things taken together will be called as a pleadings. Very clear with this. So you can say that pleading is a very important step in the suit or in the appeal. Very clear with this. Without pleading, we do not have base for the suit. Generally, it is misunderstood that whatever happens in the court of law is pleadings. No. Pleading means written statements by both the parties submitted to the court of law, which is the beginning of a suit, is called as a pleading. I hope I'm clear now. Okay. So now let's see how the pleading is defined under CPC. Pleading means a plaint or a written statement. I have included both because it includes both of it, plaint plus written statement. Very clear with this? No. His author, he has elaborated this definition and he says that pleadings are statements written, drawn up, filed by each party to the case, stating what his contentions will be at the trial and giving all details that his opponent needs to know in order to prepare his case in the answer. Very clear with this? Understood? Okay. So in short, pleadings are nothing but the foundation of any litigation. Okay. Now, what is the object behind the pleading? Why we need to submit it? Just imagine you go to the court of law and say to the justice that I have so and so problem, please solve my case. Will he be able to solve it or give you the decision? The answer is no, because he has nothing in his hands to read. He needs to study the case. It's not easy to give justice. When we sit in the chair of a judge, then we understand how difficult it is to give the judgment. Very clear with this? Okay. So pleadings are very, very important for the judgment. Very clear with this? Understood? So what is the object? Let's learn. There are three important objects. All the issues which are there of the party should be included in the pleadings. Okay, it's very important. It also provides opportunity to both the parties to know well in advance at what all things are going to come up against them. Okay, and it will also make understand the court what is the real intention of this particular suit. So this is the object of the pleadings. Now let's understand what are the fundamental rules for pleadings. See, these fundamental rules are very, very important. This can be asked in the paper. Okay, and this we are going to learn elaborately. Let's understand the first fundamental rule of how to draft and what to draft in the pleading. Our pleading should contain the facts only. It should not contain the law. What do you mean by this? I mean by this is, as I give you example of a debtor and a creditor. So we can't say that as per Contract Act, he has repudiated my contract, updates my contract, and he is liable to pay me this. No, this judgment court will give you. You did not state what is written in the law. You need to state what is a fact. So what is a fact in our example? On so and so date, Mr. A, the debtor, took a loan from me. Second fact is that he promised to repay the debt after 5 years. And after 5 years, on so and so date, he refused or he is not able to pay the debt. On my request, after giving him 3 months more time also, he is not answering my call or whatever. All these things are the facts and only this has to be included. We cannot include the law in that. You understood? Yes or no? Okay, so this is the first rule of a pleading. So what is to be stated? Please remember only facts and not the law, because law will be decided by the judge. They are sitting there. Now, there are certain exceptions to this rule. What all things we can include? Foreign law we can include. Okay, like we can give reference to the foreign law judgment as decided in so and so case. This case is similar to the foreign case. This we can give. Any Hindu custom. Okay, like for example, it is regarding to any marriage or any settlement between two brothers or two sisters, whatever. We can give reference as per Hindu act or as per Hindu law. This is what is our custom. So please take this into consideration. When the law and fact is mixed together, we can write that law. When legal pleas are involved, we can write that. When we want to give any reference of other law, we can put that. Okay, these are the 5 exceptions to the first rule. Please remember this. Now let's understand the second rule. Second rule says that only material facts can be put in the pleading, that means the plaint. We cannot put irrelevant fact. Now what is relevant, what is not relevant may not be known by a layman. but yes, definitely it can be known by a lawyer. Okay, have you guys seen any movies like क्योंकि मैं झूठ नहीं बोलता or where law scenes are involved, ऐतराज? You might have heard the sentence, objection, my lord, this is not relevant, and party is trying to threat my client. You guys might have heard all these sentences in Hindi. I'm just translating it. Okay. So what do you mean by that? That the objection lawyer, what he is proving that the uh, appellant lawyer, whatever he's saying, those facts are irrelevant. Why he is trying to do that? Because it is his duty and he is trying to protect his client. Very clear with this, understood? Hence, if we put the irrelevant facts in the pleadings, that means the plaint itself, it might be possible that court might lose its track. Okay, so where the attention needs to be taken, where call has to be taken, over there judge might not reach because of irrelevant matter which has been inserted in the pleadings. Very clear with this? Since it's very important to put only the relevant matters and not the irrelevant matters. Yes, definitely there is exception to this rule also. First exception talks about the condition precedent. Condition precedent means what? So for example, condition precedent in our example was that a debtor will pay the creditor only if, sorry, a debtor will pay the creditor only when creditor will ask for money. This was a condition precedent which was written in the contract. So this is a condition precedent. We need to put it. See, calling of creditor to the debtor is not relevant at all, because what does the law say? On the due date we have to pay, correct? But this is what is condition precedent for the payment as per the contract. So this we can put in our material facts. Very clear with this? Second exception is that presumptions of law. You might have heard about this. Every chapter has its own presumptions. In case of a criminal acts, if person has done some crime, everybody knows that he has done some crime. Correct? Understanding? But court will assume that the person has not done crime unless it is proved in the court of law. Yes or no? See the incident, take the example of this 2611. Okay, you remember the word kasab. Yes or no? Okay, he was hanged till death. But it took so long. Incident happened in 11 and he was hanged almost after 3 to 4 years. Why? Everybody has seen him. But what is the rule of law? That court will presume him to be, not convict until and unless it is proved in the court of law. Very clear with this? These are the presumptions of law, and this can be included. Then inducement. Another exception says that mere things which are introductory, like parties, names of the parties and all, this can be put in the material fact, but it needs to be shortened, because if you give history of your appellant and defendant, like he is daughter of this and MLA and father of this, it would be too long, and then judge don't have so much of time to read all these things. Okay. Facts, not evidence. This is very important exception. Okay. At the pleading level, we have to just insert the facts but not the evidences. Evidences we have to preserve for the court hearing. So we cannot put all the evidences in the plaint, otherwise the plaint will go into pages and pages. Understanding? Because what is pleading? Pleading is just an introduction about what is the crime, who all are involved, and what is the relief which they want. That's it. All other things have to be kept for the hearings. Very clear with this. In evidence also there are two types of evidences. One is facta probenda, another one is facta probentia. Now what do you mean by this? probenda is introduction to the suit. Yes, this we have to introduce in the pleading level, because without this we cannot understand what is a suit about. Probentia means it is one type of evidence, means if this is proved, then relief will already be granted. Understood? So this part we have to keep at the hearing stage. Very clear with this? Understood? Any doubt? This was rules. Now let's see the exception to this. When we are filing a writ petition, you might have heard what is a writ petition. Whenever fundamental rights of any citizen is breached, which is given under Part 3 of Constitution of India, they can directly go to the High Court and Supreme Court by filing the writ petition. He need not go to the lower level of court. This is the writ petition. When we are filing the writ petition, we need to give all the evidences in the writ petition only. We cannot wait till the hearing. This is the only exception to this. Very clear with this? Okay. The third rule is that facts have to be very concise and very precise. We cannot write long answers as we write to lengthen our paper. We cannot do this because we are not drafting your paper. We are drafting a petition which we are going to file in the court of law. Understood? So it cannot be vague, it cannot be obscured, it cannot be ambiguous, it needs to be very concise. But yes, while being concise, we have to remember that we have to put all the facts which are material. Just for reducing the or shortening the length, we cannot omit anything. Understood? Hence, it is to be concise and precise both. The last rule. Okay, yeah. So these are the rules which we need to follow while draft. I'm sorry, there was some connectivity issue. I hope now video and audio is clear, isn't it? Amsa Lakshmi, can you please confirm so that we'll proceed? Okay, fine. Chalo. So this were the rules of the pleadings. Now let's see the points which we need to take care while we are drafting a pleading. Okay, while drafting a pleading, it can be either a plaint or a written statement for a defendant. Okay, so please remember this part. Names and person, places to be accurately given, correctly spelled, and all the spellings what we write should be followed so that there is no confusion at all. Okay, fact should be in the active voice. Okay, all circumstances, paraphrases we cannot put it. We should avoid all those things. Okay, short blunt statements we cannot put it like we put in the WhatsApp group. No, it's not an informal plaint, it's a formal plaint. Okay, it's buts avoided. It does not create a good impression. Pronouns should be less used because he she can be defendant or the appellant, so we should use the word plaintiff and defendant, or at least names of them. Best way to use it, the plaintiffs and defendants. Okay, this is what I told you. Okay, things should be mentioned by the correct names. Whatever we are writing, we should be very precise about that. We have to be clear about the things which we are writing. Okay, some things we might not be sure of, so we cannot write those things. Very clear with this? Understood? Now, when we are writing some law name like Companies Act 2013, we cannot write the short forms like CA, 2013. No, we have to use the full forms. We have to write the complete name of rules and schedules, everything. Very clear with this? Understood? We cannot use word if, but, that, either, or. No, it does not create a good impression. Okay, necessary facts, everything should be included, material facts, whatever is there. Pleading should be divided into paragraphs and every allegation should be in different paragraphs. We cannot combine two allegations in one paragraph. Dates, numbers, sums expressly included in figures and words like we do everywhere. Understood? Then pleading will be signed by the party. or the representative of the party by giving the wakalatnama. Understood? After it is signed by the party or the authorized representative, it needs to be verified. Verification is compulsory for the suit or the pleadings. Understood? Remember, it's not compulsory while we file the memorandum of appeal. Please remember this. Then verification will be done by the plaintiff or defendant himself or anybody, any other person authorized. But after verification, he needs to sign that I hereby verify whatever is written in the plaint is true and correct. Okay. These are the things. Now let's go to the next level, pleadings. There are civil classes of the courts. We know that we have district courts, we have high courts at the state level, and we have one Supreme Court, which is only one in all over India. So in all these courts, we file the civil suits. In the criminal suits, we have magistrates, we have chief magistrate, we have executive magistrates, we have metropolitan magistrates, then we have high courts, then we have session courts, then we have Supreme Court. So these are the levels of the court which we have already learned at various levels. Now let's understand what is the plaints in the paper, what all things can be asked, the fundamental, what is pleadings, the fundamental rules of pleadings, then how to draft a plaint, what are the things which can be taken into consideration for drafting the pleadings. Okay, and very important part, you need to read the drafting part, practice at least one draft every day, then you can definitely clear in your paper. Understood? This subject is not that difficult. Believe me, it's a scoring subject. Okay? Now, how to draft a plaint? Plaint means what? In the civil law, the initial step which aggrieved party takes to go to the court of law is called as a plaint. Understood? You can tell it as a suit. You can tell it as a petition as well. Now, what all things will be there in the plate? The name of the court will be number one. Then place of residence, name of the plaintiff. Then description of place where defendant is residing. Okay, whether the plaintiff defendant is minor, then who will fight the case on behalf of them. What is the cause of action? Where did it occur? Which court has the jurisdiction? What is the relief claimed? Whether any set off has been claimed by a defendant or not? What is the value of the subject matter? What will be the court fees? Everything has to be written in the plate. In case of money suits, important part is money. How much is the claim? If it is relating to the loan, we know what is a loan amount. Along with that interest, we can calculate and we can put it in the plane. But if it is relating to any profits of a partnership firm, or if it is relating to any valuation of the property, immovable, movable, whatever, we cannot evaluate the value, then we have to put the approx cost that will determine by looking at the market value of that. But yes, we need to put that amount. When plaint is regarding the subject matter, and subject matter is the immovable property, we have to write all the details of that immovable property, where it is located, what are the boundaries, who is owning that, and today what is the value of that property. When plaint is regarding suing of the representative, okay, then we have to show what is the actual interest. Excuse me. What is the actual interest in the subject matter? How representative is interested in our subject matter? So this is what is very, very important. Now let's see how our plaint will look. The first will be heading title. The first thing which will come in our plaint is the name of a court. So how we will write? In the jurisdiction of the city civil court. This is how we have to write. So first will be the court name. So where we have instituted our suit. After that, names of the parties will come. Who all are the plaintiffs? Who all are the defendants? Just for your knowledge, The person who files the suit is called as a plaintiff, and on whom suit is filed is called as a defendant. Very clear with this? Understood? And in case of a appeal, it is appellant who files the appeal, and respondent means on the other part. Clear? Then we have to write or the names. After the names, what all things will be given? Whether the plaintiff or defendant is minor, if or unsound mind, and if they are so, then who will fight the case on their behalf. Then next we have to write what is the issue. That will come in the second, that is the body of a claim. Okay, please remember this. Heading and title is clear. Now let's go to the body of the plaint. It will cover into various paragraphs. Okay, every allegation, different paragraphs, as I told you earlier. Date, time, numbers, we have to write in word as well as figures. Please remember this. Okay, now how do you start? We can start like this. The above named plaintiff states as under. So this is how we start. What the plaintiff has to say. Okay. That this things happened. The loan was due. He did not pay. All the facts have to be put over here. Understood? Remember, only facts, not law. Now your Moga has divided pleading into two parts. First part talks about the substantive portion. Second part talks about the formal portion. Now here, what does the substantive part has? Substantive part has everything, like what is the cause of action, how the defendant is interested in the plaintiff's case, everything will come in that. That is introductory matter is called as a substantive portion. Very clear with this? Second portion is called as a formal portion, where when did the cause of action arise, the date, what are the facts of that, what is the valuation of that, whether the plaintiff or defendant is minor or not, and then who are the representatives, and whether suit is filed before expiry of limitation period or after. If it is filed after, then how did they file how did they file after expiry of the limitation period, what is the relief sought, then signature and verification. This is what we have earlier discussed, correct? After verification, it's compulsory to attach the affidavits. Okay, affidavit is where you might have heard about the affidavit, correct? What is affidavit? It's a personal oath which we take in front of a oath commissioner or a notary, and then they sign, and then we submit that whatever we have given in the plaint is true and correct. Very clear with this? Any doubts? So then it's very important to attach the affidavit. Any doubts in the structure of the plaint? I hope it is clear now. Yes, Hamza Lakshmi. Now, can we go to the written statement? That means on the defendant side. Okay. Defendant side, see, when this such type of plaint. Okay, just a minute. When such type of plaint is received by the court of law, and court of law feels that yes, there is some prima facie case, it will serve the notice to the defendant, okay, and then also ask for a written statement within 90 days. Generally, it is 90 days, okay. Then such statements, if there are more than one defendant, then court has to serve notice on all the defendants. Now it's duty of defendants to respond. If they don't respond on time, the court will give them time. Then ex parte opinion or ex parte statement or judgment will be passed. Very clear with this? Understood? Defendants also, they can together jointly, if they have only one contention, one opinion, they can file only one written statement. If they have different opinions, they can file different written statement. But yes, lawyers for such contradictory statements will be different, because one lawyer cannot plead on both the sides. Very clear with this? Understood? Okay. Then how it is drafted. What is the formal portion? Okay, as I told you earlier, it can be single defendant statement or it can be more than one defendant. And how do you start? There will be a heading, title, same like the plaint. Okay, then you have a case number, you have the court name, the party's name, then you have to start like this. Written statement on behalf of all the defendants or written statement on behalf of defendant number 1 and defendant number 2. This is how we can write. Then we have to continue or we can start the written statements by writing the defendant states as follows. Then we can start our statement. In the written statements, we need not claim any relief. It's not required. But yes, when we are claiming the setup against the plaintiff, we have to put the relief in that. Very clear with this? Then, body of a written statement. Now, there are various kinds of defenses. First kind of defense is traverse. Traverse means what? Defendant completely disagree to the plaint, that he does not admit any of the allegations which are put up by the plaintiff. So that defense is called as a traverse defense. This can also be asked in the paper. Okay, what are the forms of defense? Second defense is confession and avoidance, or you can say it as a special defense. That defendant is confessing, yes, I have done that, but what he is trying to do, he is avoiding his what you can say, avoiding his punishment by stating different facts which are not relevant. Like for example, he will say, yes, I had taken loan and yes, I admit that, I confess that I am not able to pay it because I am having operation of my mother, my wife, and please, court, I hereby request not to give me harsh punishment. So he will tell n number of things. So such defense is called as a special defense. Okay. Then third kind of defense is objection in point of law. Okay, this is something very different. He is not agreeing to any of the allegation, but what he's trying to do, that he's trying to point out some defect in the plaint itself. That means the plaintiff has not paid adequate sum of court fees. This particular court do not have jurisdiction to entertain this suit. So what it is trying to do is trying to take out some point of defect of law in the plaintiff's suit. Very clear with this? Understood? Okay. Now there can be n number of objections, like you have misjoinder of parties or you have non-joinder of parties. Misjoinder means what? Suppose there are 4-5 parties who have together filed the suit by assuming that the fact in question is same, but actually it is not. So it is an initial, or you can say it is a preliminary objection which court allows. Later on, at the time of judgment, if someone says, if defendant or some other party says that this is misjoinder of law, court will not listen to you, because court will say you should have pointed this out at the time of preliminary objection and not after the hearing is done. Very clear with this? So such type of objection is only allowed at the preliminary stage and not at the later stage. Very clear with this? So these are the types of the defenses. Defendants may take up any of the type, singly or jointly, whatever. He has to put all the grounds of his defense. He has to insert each and every statement, because later on he may not be allowed to be raised. Very clear with this? Now, how to draft a written statement? There are certain rules. Okay, denials. Whatever he is denying, he has to be very precise and very specific. He cannot be ambiguous on the denials. Okay. Second type is dilatory pleas. Okay. Dilatory pleas means what? He does not give any substantive reply. He's just doing time pass to waste the time so that he can, extend his punishment. That is called as a dilatory pleas. Then objection to point of law, I've already told you. The defendant will try to point out the objection in the plaintiff's plaint. Special defense also, I told you, he's confessing, but at that same time what he is doing, he is giving some special arguments. Okay, so that court will lose its track. Okay, set off and counterclaim. Set off and counterclaim means what? I'll tell you. Suppose Mr. A is owing 5,000 from B. Okay, and Mr. B is owing 3,000 from A. Okay, so both are debtor and creditor for each other. Now, on the due date, B did not did not pay 5,000 to A, and due date for B is far away. Okay, so now B filed a suit against A saying that you did not pay me. So when he filed a plaint, B, A also said that you also owe me 3,000. So what A is doing over here, he's trying to do set off and also counterclaim. On claim, he's putting his own claim and saying to do the set off. Very clear with this? Understood? Yes or no? Definitely there are certain rules of set off. Okay. Any doubts still here? Hamza Lakshmi, I hope everything is clear this time. Now next we have to remember certain points while drafting the written statement. Denial has to be very, very specific. It cannot be vague. Otherwise, it's not a good written statement. Okay. Whatever issues the plaintiff has raised, each and every issue has to be answered. If you omit any one of them, it will affect the judgment. Okay. Then defendant should attach all the evidences he has, relevant correspondences, invoice, challans, all the documents at the time of written statement. Okay, reply has to be given to each and every. I told you earlier only. Okay, after reply has been given, it needs to be signed. Okay, it needs to be signed by the attorney of the opposite party. Very clear with this? If he is individual, if he is a partnership firm, then any one partner is authorized to sign the suit in the partnership act or in the agreement he will sign. If the party is a body corporate, any director can sign who has been authorized in this behalf. Okay, then this written statement is also to be supported with the affidavit like we support the plaint. Okay, then it cannot be read and petition should be dismissed summarily if we do not attach the affidavit. Very clear with this? If you think the reply will go in pages and pages, and we have to attach the schedules also if at all required. Okay. Now we have to attach all the necessary papers along with the written statements, because later on, if not attached, it may not be allowed later on in the court of law during hearing. Very clear with this? Understood? Okay. Chalo. Yeah, this all things we have understood. Written statement cannot have the relief part. Very clear with this? But yes, when he is claiming counter claim or set off, he can put that part in it. Okay. In which party have to put the relief? Definitely the plaintiff have to put the relief, because what is the general principle? General principle says that whatever will be asked, only that much will be given. Court will not give you something extra. Understood? Okay. Now, next, interlocutory application. Now, what all things we have discussed: how to draft a plaint, how to draft a written statement, that is defense. Now we'll go to interlocutory application. Now, what is this? This is not the final decision. When we file the petition, and we know that hearing will take 4 to 5 years. and in that, suppose the subject matter is deteriorating, or you feel that if action is not taken on time, then subject matter would be destroyed by the other party. Then we will file interlocutory applications. That interlocutory application is between the trial and trial has not been completed. Very clear with this? And such applications can be for injunction, for sale of perishable goods, and anything to protect the nature of the subject matter. Very clear with this? That's why we file the interlocutory applications. Okay. Then let's go to the original petition. What do you mean by original petition? You suit and petition, these two words are used in. It can be filed by any party, defendant or plaintiff. Whoever feels that there is a danger to the subject matter, and if not saved, if action not taken, the other party will definitely ruin that. Understood? It can be filed by both the parties. Okay. Then original petition. See this. There are two words: suit and petition. Okay. Generally, suits which are claims which are filed with the district court are called as a suits, and claims which are filed with the High Court and the Supreme Court are called as a petition. This is how we say, but both words are very generally used. Okay, understood. Even we can say plaint which is filed with the district court. Even you can say it as a petition. Clear with this? Now, because there were burdens in the, on the district court and high court and supreme court, you know that various special courts have been formed, like Companies Act. You have income tax tribunal, you have appellate tribunal, you have SAT. N number of tribunals are there, correct, to hear the appeals or to hear the petitions. So all the claims filed in such courts, even we have NCLT, we call it as a petition and not a suit. So both words are interchangeably used. So we cannot infer. Both are the original one. That means first time filed in the any court of law is called as the original petition. Very clear with this? After that, if any party is not happy with any judgment, then we file appeal. So second suit is called as an appeal, that is for sure. And third is called as a second appeal. Understood? Okay. Then let's talk about affidavit now. If we say it if it's said legally, it is a sworn statement in writing made specially under oath before authorized officer. Clear with this? Any doubts? Okay. If court any time thinks that this has to be supported along with the affidavit, then court can ask you to do that. Nowadays, even while taking admission in the colleges, this process is done to know the exact identity of a student. Very clear with this? Now we have to remember certain points while drafting the affidavit. Okay. We cannot put any single allegation. Okay. Absolutely. It has to be inserted very properly. Okay. Person making affidavit should be fully described in the affidavit, that who is making the affidavit. Okay. Then affidavit should be drawn up in first person only. That means if I want to draw my affidavit, I'll say I, Vandita Doshi, aged this, resident of this, daughter of this, wife of this, everything. I have to write in my voice only. That is the first statement. It can be divided into paragraphs. It should be numbered consecutively. Okay. Then every person and place has to be correctly described in the affidavit so that there is no ambiguity. We have to use words like I take an oath, I affirm. We have to use these positive words. Okay, are you clear with this? Then it is like, as per my knowledge, this and this facts are there. So we have to put our own personal knowledge in it. So whatever we are stating, I am sure about it. That is only what is called as an affidavit. Understood? And if we refer any documents, then we have to attach that in the affidavit and give that reference in the affidavit itself. Okay. At last, when we are signing, we have to use this. I swear that this is my declaration, which is true, that it conceals nothing, no part of it is false. This has to be inserted in your affidavit. Okay, so please remember this line, and if affidavit is asked, you have to use it like. Okay, then it will be signed by the person who is making the affidavit. It will be authenticated by oath commissioner or notary public or magistrate or any other authority. Understood? Yes, stamp duties are chargeable on the affidavits, but affidavits which are used in the court of law, for the court of law used, it is not, it is duty. Okay. Execution of petition. Now, once the judgment has been passed, on whose favor the judgment has been passed, he gets a decree. Okay, then he has to affidavit be treated as an evidence. Yes, why not? It's a written document. Definitely, it will be treated as an evidence. Okay, yeah. Execution petition means what? I have a decree in my hand that I can take 5,000 rupees from Mr. B. So now I want to execute it. Okay, this is what is called as a execution petition. Okay. So who can file the execution petition? Who has got the decree can file the execution petition. Suppose the decree was oral, then there is no need of written application. Oral application will do, because it is on the spot execution. Like if court says that the person is convicted and sentenced to 10 years, then at the same time police officers will take him in his custody. So over there written application is not required. Okay. Then where written applications are required, suppose there is injunction order, suppose there is recovery of some money, etc., etc., then we have to file a written application in the court of law. It will be signed by person who is filing it and verified by the applicant himself. Okay, hope there are no doubts till now. Then memorandum of appeal and revision. What is this? Till now, whatever we have studied, it was relating to suit and petition, first times filed. Now, any of the party aggrieved against whom decision is gone, he is not happy. He wants to go to the higher court. Okay, so appeal is nothing but continuation of a case only, but in the higher level and not the same level. Very clear with this? Understood? Any doubts? Even revision happens at the by the higher court and not the lower court or not the same level court. Clear with this? Okay. Let's first understand what is memorandum of appeal. First appeal is the first time we are filing. Second appeal is always filed in the high court. That is a appellate court. It always in the high court and not the lower court. Very clear with this? First appeal can be filed for matter of fact and law both. There is question of fact and law. Second appeal lies only when there is some substantive question of law and not the fact. Understood? Now there can be a question, now when do we go to the Supreme Court then? We can go to the Supreme Court when High Court gives a written statement that there is a substantive question of law and it is very urgent that the highest court of land should take this suit under consideration. Then we can go to the Supreme Court. Very clear with this? Understood? Any doubts? Okay. So if it is asked whether appeal is continuation of proceeding, the answer should be yes, it is continuation of the proceedings. Under CPC, there are four kind of appeals. Okay. First appeals are from original decrees. It can be filed at the district level, high court level. Okay, and it can be for question of law and fact both. Second appeal always lie with the High Court, and it is only for substantial question of law, remember. Okay, any doubts? Now, appeal from orders. There are certain orders on which we can file appeals. Generally, appeal are possible only in case of decrees, but there are certain order under CPC, CRPC where we can file appeals. Now, only these orders are appealable, all other orders are non-appealable. Okay. Then there is order under 35A where compensatory costs are there. Okay, that person has done some act because of which the victim had to bear some damages, okay, and because of which special cost has been incurred. So such orders, appeal can be filed on such orders. Second is refusing leave to institute a suit. Person is not allowing a person to file suit in the court of law, and one court has not agreed and the person wants to go to the higher court. It is appealable. Okay. Okay. Other order, compensation for obtaining arrest, attachment, injunction on insufficient grounds. Order under code imposing fine or directing detention or arrest of any person. And there are other certain orders which are appealable orders. Apart from this, other orders are non-appealable orders. Please remember this. Then what is the recourse when order is non-appealable? They can ask for the revision, apply for the revision in the High Court. Understood? I will get back to it. Now, fourth type of appeals are under CPCR appeal to the Supreme Court, the highest court of land. Now, when will Supreme Court come into picture? Now, this authority has been granted by, first of all, section number 109 of CPC. It states that Supreme Court, the appeal can be filed over there if High Court certifies that the case involves a substantial question of law of general importance and opinion of High Court said the question needs to be decided by the Supreme Court. This is what is the opinion of High Court. Then Supreme Court will interfere. Clear with this? This is first authority given under section 109. Authority is given under section 132 to 135 of the Constitution. So, I'm sorry, I need to correct myself. Article 132 to 135. Okay, 134A talks about appeals in constitutional cases where there is some breach in the constitutional law and substantial question of law is there as to interpretation of the Constitution. Then definitely Supreme Court has to take up the matter. Second authority has been given under Article 133 of the Constitution, which says that High Court has certified that decision appealed against must be judgment, decree, final order of High Court, which is territory in India. Judgment, decree, final order should be given in the civil proceeding, civil case. Certificate has to be received from the High Court that there is substantial question of law, and opinion of High Court is that decision needs to be taken from the Supreme Court. This is what we have learned over here. Same thing. So where did this come from? You understand it has come from here. Article 133 of Constitution. You understood how do we derive powers from the Constitution? Okay. Then third, appeals in the criminal cases. There is very, very limited criminal appellate jurisdiction on the Supreme Court. It has been conferred by Article 134. Now, when can we go to 134 or rather Supreme Court? We can go without certificate of High Court. We can go with certificate of High Court or appeal by special leave. There is a special leave we have to take from the authority for filing appeal to the High Supreme Court. Very clear with this. So there are in total 4 kinds of appeal. Any doubts? Okay. Now, rights of parties in appeal. Now, what are the rights of parties in appeal? We have to remember this. Parties in appeal cannot give any extra evidences. This is a general rule, correct? Whatever has been given in the original petition, only that much can be given. No extra documents will be taken note of in the appeal. But there is exception to this rule. There is right of parties that they can produce extra documents in the following cases. Now, when lower court has refused to admit the evidences, they can put it up in the higher court. When party seeking to produce additional evidence, he did not produce without his fault. Okay, it was not his fault that he does not produce a document. Okay, appellate court himself told to produce such document which was not produced in the earlier decree or any other substantial cause. Very clear with this. But yes, appellate court have to write the reasons why they have allowed the additional documents. Very clear with this. Please remember this point. Now, how to draft a appeal? Appeal basically has three parts. First part is formal part, second part is material part, and third part is relief part. Same like the petition. Understood? How it will begin? The name of the court, then a year when it was filed, okay, name and address of the two parties, who is the plaintiff, who was the plaintiff, who was defendant, now who is the appellant and who is the respondent. Everything has to be given, that is introduction. What was the order passed by the earlier court, okay, and we have to write like this: above named appellate appeals to the court of dash from degree of dash civil judge at dash and suit number dash passed on so and so date and set forth the following grounds of objection to decree appeal from. So what are the objections also by the person who is filing the appeal have to be written. Very clear with this? Okay. Now, what are the grounds of appeal? What all things we can write? P means the person who is filing a appeal. What he can write? He have to write all the things. That is any mistake which lower court has done. He can point out that. Mistake in view of law entertained by lower court. Misapplication of law and facts. Any material irregularity, that means in conducting the proceedings, if anything which is irregular, any substantial error or defect or procedure, okay, any error in any interlocutory orders passed, whatever, and which are not available. All these things has to be included in the grounds of appeal. You have to take care in drafting grounds of appeal because it needs to be precise and very clear. It cannot be ambiguous. If we draft ambiguous grounds of appeal, and 100% our appeals will be rejected. Okay, it should be very concise. They must not be framed in narrative or argumentative form, and each distinct objection should be stated in a separate ground, and it should be consecutively numbered as well. Okay. Now, the last part of appeal is relief sought. What is the relief? As I told you earlier, relief is very, very important. Court will not give you anything which we have not asked for. Okay, so we have to write everything in absence. But over here, the thing is different. If we do not write the relief, court will not, fatal it. Fatal it means what? Court will give you whatever you deserve, not like the plaint. So this is the difference between plaint and memorandum of appeal. Remember this difference if it is asked. In plaint, it is compulsory to write relief. Without relief, we will not get anything. In memorandum of appeal, it's not compulsory. But yes, it's very good practice to write a relief. Any doubts? After the relief, we have to sign. Who will sign? The applicant has to sign. Okay, very clear with this. If applicant is not there, the counselor will sign. If there are many applicants, all of them will sign. and it needs to be practically there is a verification, but it's not compulsory in memorandum of appeal. One more point of difference between the two. Okay. Any doubts in appeal? Now let's go to revision. Now what is revision? Revision is not continuation of case. Okay, like appeal. It is fresh start of a case. Now let's understand what is revision first. Suppose the High Court is sitting idle, don't have any work. Sorry, this does not happen. Okay, High Court has taken up one particular case. Okay, and he has seen that there is some irregularity done or mistake done by the lower court. Then High Court will ask the question to the lower court that why such matter has been taken up and in this way. This is something which is called as revision. This is the initiative by High Court. Now I will tell you other initiative. Initiative by an aggrieved party. That means order has been passed by a court or appeal has or the decree has been passed by a court which is non-appealable. Non-appealable means they cannot go to the higher court, correct? So now what is a remedy? They can go for revision to the high court. Very clear with this? Understood? So revision is possible only on those matters where appeal is not possible. Understood? Okay. And what is revision? It is a fresh start of a case. Hence, fresh wakalatnama is required for this. Understood? In appeal, fresh wakalatnama is not necessary because it is continuation of case. Okay. So let's understand the jurisdiction of the High Court. When can High Court accept the revision? If the lower court has exercised the jurisdiction which they do not have. Okay. If to have exercised the jurisdiction which is not wasted, to have failed to exercise the jurisdiction which is wasted, and to have acted in exercise of his jurisdiction illegally or material irregularity, then High Court can make such order for the revision. See, remember, in revision, they cannot reverse the judgment. Okay. But what they can do is they can just, what I can see. They can just see to those mistakes which has been taken and while the trial of the cases. That's it. It cannot reverse the judgment. But yes, there are exceptions to the rule. There are instances where High Court can reverse the judgment. Now, when it can happen? It can happen when, suppose, party had a right to appeal, and if appeal was filed, definitely the judgment would have been reversed. In that case, High Court may reverse the judgment, and they have right to reverse. Okay, if High Court thinks that if this decree gets executed, then there would be failure of justice. That means it is everybody knows whatever judgment has been given is wrong. At this point of time also they can reverse the judgment. Okay, very clear with this. In only two circumstances they can reverse, otherwise they cannot reverse. Now revision can be in civil as well as criminal. Okay. Now when can party in civil case go for revision? When he does not have any other remedy, that means the order is non-appealable and the decree is non-appealable. Only then they can go to the High Court. Now let's go to the complaint, that is criminal side. I hope the civil side is clear. Whatever is plaint in civil law, same as a complaint in the criminal law. Now how this starts? This scene starts with the FIR, that is first information report. If see, there is a very much difference between civil law and the criminal law. Civil suit can be instituted only by the aggrieved party himself, but criminal suit can be instituted by anyone. Apart from there are there is some personal matters like marriage and dowry, etc. etc. Understood? Okay. So it starts with FIR. If you have seen any person beating like animal to someone, you need not wait for that person to go to the police station. You can go to the police station, okay, then file FIR over there. That means you can say the state the matters. Police will write FIR, first information report. Police will investigate the case and give it to the magistrate, which is called as a complaint. Understood? Remember, what is a complaint? What we directly file with the magistrate, that is a complaint. Appeal. GH High Court had ordered for revision if before filing appeal. No, see. High Court can order revision only on then no appeal can be filed. Appeal has first right. Understood? Appeal means initiative by person himself, and revision is initiative by the High Court as well. So where High Court, okay, I understood your question. Now High Court has ordered for the revision. Okay, but in this case, High Court cannot reverse its decision because party is having right to appeal. Understood? His right to appeal will not be taken away just because High Court has initiated the revision. Understood now? Got my answer? Okay. Now, yeah, we were at the complaint, right? So first part, what is a complaint? A complaint is filed to the magistrate directly, but it does not include a police report. Please remember, complaint does not include a police report. But when we file the FIR, police carries out the investigation. After investigation, they make their own report and they submit it to the magistrate. If there is any crime committed, such report now can be called as a complaint because it is done after the investigation. You understood what I am saying? Okay, so please be clear. Police report submitted without the investigation will not be part of a complaint. Police report submitted after investigation will be part of a complaint. Very clear with this? If I say FIR is a complaint, the answer is no. FIR is not a complaint. Clear with this? Understood? Okay. So petition submitted before district magistrate or a superintendent of police, it is not a complaint. Okay, please remember this. Okay, now what are requisites of a complaint? Can be oral, it can be written allegation. Okay, it can be some person known unknown who has done an offense. It must be made to the magistrate himself. It must be made with object that he should take action on it. Okay. Now suppose the removal of public nuisance. Now the pandemic is going on and orders are that we should not gather. Suppose you see some crowd, okay, nearby, and you call 100, the police. Can police say that no, you are not, no, it is not our duty to do it? The answer is no. They will immediately take the action, right? Because it is a public nuisance. And public, for removing the public nuisance, the call given to the police station will also be practically called as a complaint. Very clear with this? Understood? Any doubts? Okay. Now, criminal miscellaneous petition. Now, this is like you know, interlocutory orders. As we file interlocutory petition between the civil suit, these are the same way interlocutory petition between the criminal suit. Okay, miscellaneous means what? It is mixture of many things. When the person, a defendant or appellant or plaintiff or defendant cannot wait till the end of the suit, they want some interim relief, then they will file the miscellaneous petition. And as it is filed in the criminal law, it is called as a criminal miscellaneous petition. Very clear with this, okay? Now there is a difference between petition and a memo. Suppose any person wants to give some information to the court of law and relief is not asked for, then it will be called as a memo and not petition. If someone has filed a petition and asked a relief on that, it's a petition and not memo, because it is a relief which they want to take from the court of law. Very clear with this? So please remember difference between petition and memo. Okay. Know what is a bail? Bail is possible in the bailable offences, that is in non-cognizable offences where offences is not serious enough. Okay. So bail means what? The proceedings are going on and you are in jail. Okay. Arrest warrant has been issued against you. Now you call a lawyer and tell the lawyer, please grant me bail. Please, start preparing for my bail. Now what do you mean? Lawyer will prepare a petition which will be submitted, that is, which is also called as criminal miscellaneous petition, which we have already learned. The court of law saying that we, the parties, hereby take the surety of this person who is in jail that he will not do any act, he will not run away from the proceedings, he will not go out of this state, etc. from so and so date. Please give his custody to us. So, taking out from jail with surety is called as a bail. Very clear with this? 436 section talks about the bail in the bailable offence. 437 talks about the bail in the non-bailable offence. Understood? Where arrest without warrant is there, and when bail is granted by the court of law, it is under 437. And 438 talks about the anticipatory bail. Anticipatory bail means what? Where a person knows or he thinks that arrest warrant is going to come, he is not yet arrested, but he anticipates that he may get arrested. So what he does, he tells his lawyer to prepare the anticipatory bail document duly signed, okay, that he has done so and so offense, and because of which there may be arrest warrant. So first only he is taking bail without arrest. That is called as an anticipatory bail. Okay, but yes, it's very important. Court, before granting such bail, court will consult the opposite party that whether bail be granted. Okay, opportunity of the third has to be. Now, what is FIR? I've already told you what is FIR, First Information Report, which a party files with the police station. Now, it is duty of a police station, is mandatory for police station to register FIR. You might have seen in many movies that they generally don't want to do it, right? Because of fear of someone, or they don't care while approach. But this cannot be done. If this is done, we can contact the superintendent of police and also complain his the person's name. That person is not ready to, that police is not ready to register the FIR. Then he will take the necessary actions. So it is mandatory. Please remember this. Okay, police officer is duty bound to register the case. Okay. That's it with this chapter. Thank you so much. I hope you have understood this.